CodeX group meeting. This is, I think, it's been a while since we had our group meeting. We were teaching legal informatics in the spring quarter, so we took a short break from our weekly group meetings. But we have one before the summer, and I'm excited to have two exciting presentations here today, and two great presenters. So one is Itai Kurari, the founder and CEO of Judicata, and then we also have Federico Ast, the co-founder of Kleros, who's actually joining us remotely from Argentina. And Argentina?
I'm pretty sure.
Yeah. So yes, but before we turn it over to our speakers, I just wanted to see if anyone had any kind of updates or news to share. It's been a while since we brought the group together. We have about, 7 people here at Stanford, 20 people online. And if you are online and you want us to hear you, you have to unmute yourself. I know that Jimmy has a quick announcement. Jimmy Westbrick is running a great event tonight in San Francisco.
Yeah.
You want to say a word about
I'll say briefly, yeah, thank you for putting in the email. I'm from London, run a community called Legal Geek, and we're doing an event in San Francisco tonight, which is with Nextdoor Labs and Nextdoor Ventures. And it's a pitching competition basically for startups to win a travel grant to come over to London to our event, which has 2,000 people. It's like the whole European legal tech ecosystem. So if you're interested in legal tech and startups and you happen to be near San Francisco this evening, there's beer and pizza.
Yeah,
and startups.
Yeah, it should be a great event. I look forward to going there. Does anyone else have any kind of news to share? You can also use the chat function online. Okay, well, if there's no one with any updates, then we'll just turn it over. I think we'll go first with Federico. Federico, can you hear us?
Can you hear me?
Yes.
Yeah, I can hear you perfect. So, want me to start?
Yes, please, go ahead.
Okay, so thanks a lot for the opportunity of presenting here. Very excited. I'm just going to do a very short presentation of what Kleros is and what we want to do into the field of arbitration. And it's going to be quite short, and so then you can ask the questions you like, and very looking forward to your feedback on this. Okay, so I get a notification here. Can you see my screen?
Yes, we can.
Yeah, great. So let me start then. So how can I start the presentation? Okay, I'm trying to pass to the next slide. You know, how do I do that?
You would just do that like you normally would, just like you're in your software, just however you would advance it normally.
Yeah, but I do that, and then I get like a error sound, like that Apple error sound, like it's like locked or something like that.
Okay, then we will have to maybe
share and unshare for a moment.
Yeah.
Share and unshare for a moment your screen.
Like,
and then share again. And
I can do like anything, because every button I press in the keyboard, like I get the same error. Maybe you have logged this from your side, or
no.
No.
You may have to.
Let me see.
There you go.
Oh, maybe I think it works with the mouse. So yeah, okay. Let's start then. Let's see if we can make it work. Okay, so let's think of the case of Alice. She's an entrepreneur from France, and she hires this guy Bob, who is in Guatemala, to build a website for her, for a website for her company. So Bob delivers the product, and then she is not happy with it, and she's there is a dispute. She wants the money back, and Bob just says that he did his job and that he should not give her anything back. So this is a very common type of dispute that we are having today in the global economy because of different technological and economic trends, globalization, etc. So she's not going to court in Guatemala because it's too expensive, and none of the existing methods for arbitration are really useful for this kind of disputes, right? So this is the solution that Kleros tries to build. So imagine if instead of paying Bob directly, Alice sends the payment into a smart contract. I guess you all know what a smart contract is, blockchain, right?
Yeah.
Yeah, so great. When they do the agreement, they also agree that they are going to use Kleros as arbitrator in case something goes wrong with the contract, right? So they select Kleros as arbitrator, as in any arbitration service, and then if everything goes right, the money is transferred to the contractor, and the client gets the website. But if there is a dispute, so the money is going to stay locked into a smart contract, and Kleros is a decentralized organization that's going to select a jury of experts, of arbitrators from different parts of the world, and these guys are going to analyze the website, the product, the contract, and they are experts in this, and they are going to vote who is right in this dispute. And so after they do this, so the money gets transferred to the winner. So in this case, they vote Alice as a winner, and so the funds that were in the smart contract as an escrow, they go to her, and she's reimbursed, and so she gets her money back. So that's a basic framework of how Kleros works. So a very important question here is, so how do we select the arbitrators, right? And so the name of the project and of the company is Kleros because it means randomness in Greek. It's based on how the ancient Greek court system used to work and how they selected jurors for popular trials. So let's imagine this guy who is in Tanzania, and he works as a website designer during the day, and so in the evening he wants to make some extra money by arbitrating disputes into Kleros, right? Because he can use the skills and he knows how to do this. So he has to use a token, and this token is called Pinakion because of the name of the ancient court system that they used for selecting jurors in ancient Athens. So he has to have one of these tokens, and he's going to put the token into a virtual court where other people who want to be arbitrators in this dispute are going to put their own token, right? And so there, the system is going to choose a number of jurors from, imagine like 1,000 people put the token to be drawn as jurors, and so the system is going to pick like 5 or 7 or whatever the parties agreed on the initial contract. So, and these guys who are drawn as jurors are going to see the evidence, and they are going to analyze it and vote who is right. Kleros, so here we are using a very simple case in websites, but this can be used for like every kind of disputes in different industries, and we will get back to that later. So, as I was telling you, he puts the token into the website dispute court, and then with all these other guys, 1,000 other people who put the token, and then the system is going to select a small number of them, and these guys are going to have the right to arbitrate the dispute. So do you understand for now how it works, so basic framework?
Why do you need the tokens to select the people?
That's a very good question. And this is going to because of how to create the incentive for the arbitrators to rule disputes honestly. Let's get into that now. So the thing is that what we do for creating an incentive, what's the big risk here? So you're having the arbitrators just take just becoming So jurors and just voting randomly, like they take their phone and they vote like A, B, A, B, A, B, and like not paying attention to really the dispute and just collecting money like a malicious agent. So what we use and the token is because there are some game theory. There's a game theory incentive created by what, but the concept of Schelling point that comes from the research of Thomas Schelling. He started doing this research in this book in the 60s, and he won the Nobel Prize of Economics in 2005 for this type of research. And it works like this. So when you put like two people having to, in a situation where they have to decide, in this case, for example, which they both have to decide independently a square, and they both win if they pick the same one. So empirically, most people tend to select A6, right? Any of these squares was good enough, and they could agree on the same. But so since the A6 is more special because of the different color, people tend to coordinate into that one, right? So Kleros has a same principle of if you put a number of jurors in a situation where they have to decide independently about the same dispute, right? So about this website dispute, so and they don't communicate. So and if each of them is going to win if they vote as the rest, so then you would expect them to vote what we would call the truth about the dispute, right? The fair outcome in this dispute. So remember, the jurors have taken, they put the token into this court, and the token gets locked there until the end of the dispute resolution process. So if you have 7 jurors and you have like 6 that vote A and 1 that votes B, it's likely that the one who voted B, either he did not take the time to really analyze the dispute and vote honestly, or he was not qualified, he did not understand the dispute, he did not understand about the website, right? So that makes him vote different from the others. So the guys who vote differently from the others are going to lose the token, right? And then this generates the incentive for all of them to try to think how the majority will vote and then do the analysis to vote as the others. Long story short, and if we can get into this later if you want in the questions, but so the honest arbitrators are going to, on average, make money, and the arbitrators who try to game the system because they vote randomly just to make some easy money, they are going to, on average, lose money. So use cases for Kleros, there are many use cases into the decentralized platforms that are going to be created in the next years, and that they are already starting to exist now, like domain names for decentralized platforms, Open Bazaar, that is a decentralized eBay platform, so Origin Protocol, like sharing economy without intermediaries. So in the 1.0 world, so this like eBay or Airbnb or Uber, they already have a customer service department that takes care of disputes among users. So in the decentralized world, this doesn't exist, and Kleros is going to become like the dispute resolution protocol that is going to be used by many of these platforms that are being created right now. This is what like the vision of the place that Kleros is going to have into the decentralized crypto world. But also, another important thing for us is try to solve disputes that are happening right now in the real world now. And we are studying a number of use cases. One of them is in transit tickets. So in my city, Buenos Aires, there is an app that citizens can download, and they take pictures of cars that are parked in the wrong place. And so after they take this picture, this goes to transit judges. So we have a project to start replacing the judges, transit judges, by citizens who can vote and who can arbitrate this using this system of incentives. Another use case that we are studying now is insurance. So small claims of insurance, cars who have a small crash and there is a dispute of who should pay whom, who was guilty for this, who was responsible. So this can be solved by Kleros. And lots of small claim disputes with telecommunications companies, like credit card companies, and that kind of small claims. Basically, what we are targeting, of course, this is not going to replace lawyers or criminal trials. This is going to be targeted at mostly high volume disputes and low value. At the bottom of the pyramid, where you don't have now like a solution because courts are too expensive, other arbitration methods are also too expensive. So this is going to go to a price tag that's going to below what exists today. And also, what we are targeting is not to build a big platform for like a kind of Uber, a Google for this arbitration, but build a protocol on top of which different people are going to build companies. And this is how the Bitcoin ecosystem was created. You had this white paper in 2008 by Satoshi Nakamoto, and then lots of companies built on top of this protocol different applications for making the Bitcoin protocol accessible to users. So Kleros white paper was published last year, and we think that this will, in the future, give birth to an ecosystem of companies that are going to use Kleros through an API for dispute resolution in healthcare and in travel, in gaming, or et cetera, et cetera, et cetera. There are lots of applications that we are not even aware of. So this is a screen where users can select the arbitrator that they want to use. We have a very simple prototype. This is a screen that the juror sees when he has to arbitrate a dispute. So this is the parties submitted the evidence, and he has to vote which party is right. And so this is, of course, very clunky because blockchain, as you know, is still in early stage. So the team, 3 co-founders, I am the business guy, and then we have Clément, who is the expert in game theory and crypto economics, and Nico, who is the front-end developer. And then we are 9 people distributed in the world as many blockchain companies. I want to to mention that we have William, who is a PhD in mathematics, and he's at Toronto. He's a professor at the University of Toronto. He teaches advanced cryptography there, and he's fine-tuning all the incentive system of how we can make the incentives for jurors become better and to have them vote honestly. So he's doing the work on all that side. And we just recently joined Thomson Reuters incubator. It's an incubator created by Thomson Reuters to help the development of startups who are trying to disrupt some aspect of legal systems. And so they are going to give us lots of expert mentorship and to reach customers, and also a lot of access to the existing customers. And yeah, so very excited about this because it's going to bring Kleros to real customers. So this is a very small presentation of what we are doing. Hopefully you understood something of this. I'm happy to take your questions now.
Yeah. Thank you so much, Federico. So I'm wondering, so it seems like your system is premised on the idea that if you have several people as the jurors, that they will find the right answer. How do you vet their qualifications to decide in a particular case? Isn't it oftentimes the case that in some areas you need, maybe just one person who's an expert in the technology or in how car accidents happen, that sort of thing, to actually come to a fair conclusion. But you seem to be almost follow sort of a wisdom of the crowds kind of approach here.
Yeah. So if you want to see it into that, so from that perspective, so it's like a new stage of some larger movement that has been happening basically since the internet. So yeah, Wikipedia showed that you can create an encyclopedia that is at least as good as the Britannica without relying on the experts that were curated by some editor creating the Britannica. And you know, at the beginning, people thought, you cannot create good encyclopedia using the crowd, but then we learned that it was possible, right? So I would say that Kleros is a continuation of that trend of different aspects, different functions of the social life becoming able to be done by crowds, provided they are structured in a way where the job will be done. So we take a lot of care for the incentives of the jurors to be correctly done and to be structured in such a way that they will vote honestly. Because if not, it would turn into like some kind of mob justice and whatever. So all the Schelling point development that we are doing is exactly to have the crowd self-organize in a way that they can produce honest rulings fast and cheap.
Got it. So Chris Carr chatted a question or a comment. He says, a cool idea, congrats and good work, but also lots of moving parts. For example, if I'm paying a freelancer to do something for me, why would I lock up or put my money into your escrow blockchain up front rather than hold or wait to see the quality of the other guy's product or service before I pay any money and thereby keep my leverage over him or her? What is it about your platform that will motivate me to do that work and take that risk as a person receiving a product or service in return for paying the other side money?
So this is a two-party transaction. So yeah, you don't know if the guy is going to do a good work for you, but so the guy doesn't know if you're going to pay him, right? So both parties have counterparty risk in transactions on the internet like this one. So he wants also the same leverage that you want, right? So and this what it does, so it's like it gives you both a level play field, because now money is in an escrow and you don't control it and he doesn't control it. And so if everything goes right and you agree with the guy that the job was done according to your expectations, so money is going to be transferred. And if not, so you can go to this arbitration and recover the money. So this is already done in some way by customer service of companies like eBay. So they have that already. They don't do it in the same way, and I think they don't have the same incentives to create a fair arbitration system. So they see it as a customer service, right? But the incentive for you is like to have the guy do the work, the job for you. And think it this way also. So this makes a lot bigger the amount of people who are going to be able to transact on the internet, right? Because there's a lot more people that now you can hire from different countries, right? Because it makes like the amount of people that now maybe you only want to hire guys who are on some platforms, you know. With this, you can hire guys from everywhere, and you have the way to know if that the work was not done correctly, then you can get your money back.
Okay. Here's a Ruben actually chatted another question. He said, might incentivizing consensus potentially promote an indirect bias against minorities?
Okay, so I get this question a lot. So for the way that the system is structured, so we can hide the non-relevant information about from the jurors. So they don't know who the parties are. Like it could be structured as a peer-to-peer review system, double-blind review in academia. So you don't know who is the juror, and the juror doesn't know who is the people who is in the dispute with the parties. So that should hide from the jurors some biases. Then a deeper question is, so compared to what? So what system of arbitration really is totally unbiased? Because what a question we get quite often, yeah, what if so this type of objections, but people don't see that existing systems also have these biases, and that actually this is Kleros in this way is not going to be like worse than other arbitration systems. At least it's going to be better and cheaper and faster, right?
Mm-hmm. Are there any other questions for Federico? Anyone here or online? And what's your, how do you make money? Oh, sorry, how do you make money? What's your business model?
The business model of Kleros is so it's a token-based business model, like the tokens that like every blockchain company that uses a token for creating incentives for the system to work. So it works the same in Kleros. So the team has a number of tokens that if the platform really works as expected, will be very valuable in the future. So that's a business model for the team. And also the arbitrators also have a business model, because they make money with the skills that now they are not using. So the people who are going to be the arbitrator for disputes, now they can make money as people who work today on Mechanical Turk for Amazon. So they make money by doing some job, and so this is going to give arbitrators also a possibility of making money, in the platform.
Are they paid in tokens or in fiat?
The arbitrators are paid in, so the currency that the platform uses now is Ether. So because it's how it's built now, but the arbitrators are going to be paid in Ether. But eventually, as the ecosystem gets more mature and the arbitrators will collect, so the Ether is going to be exchanged automatically against a fiat currency or whatever they want. So yeah, and you know, the parties are not going to even know they are using Kleros. For the parties, they are going to be just interfacing with an e-commerce website, and the e-commerce website is going to use Kleros to solve the dispute as if it was a B2B provider of arbitration for them, right? So yeah, it's different business model altogether.
Okay, there's another question that somebody chatted. Is there a default number of jurors, say 7, and if people can contract for a higher or lower number, do you already see a trend in terms of the numbers of jurors people want?
Okay, so at this point, we don't have a standard number of jurors. So the optimal number of jurors is going to be the least amount of jurors that we need in order to have an accurate ruling. If we can do it with 3, it's better than doing with 5 or 7 because it's going to be cheaper. But ultimately, so the parties, when they do the agreement so we are going to use Kleros arbitrator for this dispute, so they can select in the contract how many jurors they are going to use for the resolution. And what was the other one?
No, so yeah, my follow-up question would be, but how do you define an accurate ruling? How do you know you have the right number of people to make an accurate ruling? What defines an accurate ruling? Is there some? What's the higher? Then you need a higher instance.
How would you define that? How would you define an accurate ruling, like in existing arbitration systems or justice system? What's an accurate ruling?
Yeah, but that's the point, right? So why do you need then more than one juror? It's based on the will of the parties to have another person make a decision for them.
We have like this. You have, so as I told you, so you for the first test we are doing, so we are taking disputes that already have been solved by customer service of like e-commerce system. So one of them is a partner of us that we are working with is Ink Protocol. You know the company Listia.com? It's a marketplace. So they are partners of us, and we are going to start testing our system with disputes that they already solved, all ones, and that they consider that they were correctly solved according to the standards in the e-commerce platform. So, and they're going to feed this into the system and see if the jurors of Kleros, using the incentive system that we created, if they are going to have to arrive at the same decision that the customer service department had, right? And if they can do it faster and cheaper. So that's the key test for us. And as an accurate ruling, for now, we take the decision that was taken by the best existing method, alternative to Kleros, that is the customer service of the marketplace. So yeah. And then, as I told you, we have we are in the end a science company, and nobody has used before this approach to game theory to arbitration. So there's a lot of learning to do in the way, and we don't claim to have all the answers at this very early stage of the project. So we are just about to start testing the first use cases of the platform with real users in like 2 months. A lot of things are going to be learned along the way, as things were learned along the way in every startup, I guess. So this is only the first, so how we think incentives will work, and then we will iterate.
Yeah, very final question before we turn it over to Itai. Again from Ruben. He says that arbitration really needs attention. Mandatory arbitration clauses approved in the Supreme Court last week. Do you have any plans for integration with existing arbitration ecosystems, as JAMS or AAA?
So that would be an optimal solution in some years. So now we still need to test if the game theory of this works, if the results we get are the expected ones. And then as we get to test this and confirm that it works as we expected, absolutely, we are doing this to solve real life disputes. So yes, the thing we have with the arbitration that exists already is that our system, so in arbitration, there is one very important thing, that is they want to have the identity of the arbitrator. So they have to disclose who they are, so the arbitration makes sure that there is no conflict of interest and that the arbitrator is not like the friend of one of the parties. So Kleros solves this problem about how to make a fair procedure in a completely different way using game theory. So Kleros does not ask to the arbitrators who they are, right? So they don't vet jurors by identity. So it still is not compliant with what people expect now of arbitration, but as this can prove that it works, I'm totally sure that it's going to be used, because it's going to be faster and cheaper.
Yeah. Thank you, Federico. I want to turn it over to Itai now, but thank you, Federico. It's really interesting, very exciting project.
Federico, if you could stop sharing your screen, that'd be great.
Sure. Thank you for having me. And if you want to contact me, very happy to talk to you, and maybe you have more feedback, and very welcome, because this is very new and we have a lot to improve. So thanks for having me.
Thank you. Yeah, thanks again. And everybody, yeah, you could all see Federico's email address there. And yeah, let's turn it over to Itai from Judicata.
Is speaking from here going to be loud enough?
Yeah, if you speak, you're close enough to the speaker. Yeah.
So hopefully everyone can hear me. And if anyone can't, just let me know to speak up. So what I'm going to show you today is a bit of software from Judicata, a company I founded a number of years ago, focused on evaluating the quality of legal documents or filings in court in this particular instance, which is useful for a few things. One, for actually improving the quality of the court filings and increasing the chances of winning. 2, reducing the cost through automation, but 3, primarily what I want to talk in terms of today is evaluating the quality of the lawyers, because objective lawyer evaluation has not really been something that is accessible, because the metrics are pretty subjective. So what we're going to do here with Clerk is I'm going to open up, I'm going to upload a brief. So this is a recent appeal in a case called Dynamics. It was the Supreme Court of California just ruled on this decision about a month and a half ago, and within it they changed the rule for whether a worker in California in certain circumstances is a employee or independent contractor. So this is going to take a little bit of time to do the analysis. We would get a screen here where Clerk has identified particular information. So this particular brief is an appeal from the Court of Appeal in California to the Supreme Court on a motion for class certification with various wage and hour types of causes of action. The defendant is appealing, and I would continue. After a little bit more processing, we'd end up with a report like this. So there are a lot of different use cases here, but the one, as I mentioned before, I want to focus on is evaluating the quality of the lawyering. So this particular appeal was filed by 2 of the 20 largest firms in California. One is Littler Mendelson, the other is Shepard Mullen. It didn't score too well, and while the score is sort of a proxy across several dimensions, it matches with various things that are important. Higher score means more likely to win. Higher score means you did a better job, and that's based on an evaluation of historical briefs from firms. So I'm going to go through some of the things that we saw in this Dynamics brief that were concerning. And thing to note is that this brief lost. So I'm going to start by talking about the drafting. And at a basic, one of the things that lawyers in the United States, or actually law students, learn to do is how to cite cases properly. And in this particular brief, they have a lot of just really basic, simple errors, dropping the, or adding an S from systems, misspelling Gonzalez, typing in the year wrong, things like that. So we see a lot of basic errors, which is kind of unfortunate because this is copy and paste type of functionality. Don't know how the errors get in there, but the more errors you have, statistically, the less likely you are to win. And this actually correlates with something that judges say, specifically one of the current justices on the Supreme Court of California has identified that it's important to not make small mistakes because it shows that you're a careful thinker. And if you make small mistakes, they're going to question your larger type of thinking. So with a tool like Clerk now, the judges are able to know immediately how careless or not you are with your cites. So this was filed in the Supreme Court. Second thing we're looking at here are quotations. One of the things we see is that quotations from cases and statutes are often misquoted or the page numbers incorrectly identified. In this particular situation, we've got a quote from the Chrysler case, which is the citation is to the wrong page. Another one here, one that's kind of interesting, which I don't know how this happens, but somehow the word arrangements became relationships. And we see that a lot. A lot of time it's more significant, like words like if possible getting dropped out, may becoming shall. Here it was arrangements becoming relationships. A lot of what it does look like are... So
this is a wrong quote then?
Yes, it's an incorrect quote.
Okay.
And a lot of times they're minor variations, which seem to be just the lawyer saying, well, it'll read better if I make this change. I don't know what motivated this, but these are the types of things that we see a lot of. And this is from two major law firms in California. Third thing we see is supports. So when you're citing to a legal principle, you want to cite to cases that go your way. So for example, if you're a defendant on a motion for class certification, you want to rely on cases where the defendant won. So the class certification was not granted. And so here we have a legal principle, and we see that they cite to Martinez on this, and that's actually a fine citation. But towards the bottom, we see things like language about defunding of the legislature of a certain piece of information. And they're talking about and citing to a case called Peabody, where it's not the right posture. I think it might have mixed outcomes, so it may not be the best fitting case for the scenario. And some potential other cases that might be better to cite here would be Koval, Soderstedt, or this other California Correctional Peace Officers Association. This is kind of minor, but we do see much more substantial situations where they cite to a case that actually definitively supports their opponent. We also see this in judicial decisions. The judges will write, plaintiff or defendant is relying on X case. X case actually factually supports the opponent because the other side won. So this is a check for that type of information. Another thing we do is make sure that the brief is addressing both sides' arguments. And there's a bit of a balance there, but in this particular situation, since this is an appeal, it's important that the brief address the reasons why it lost on the lower court. So we would expect here to have closer to a 1-to-1 ratio of plaintiff winning and defendant winning, or here it's a appellant versus defendant, respondent type of cases. And that's a proxy, but the proxy is we're looking at who's winning in the cases being cited, and the proxy does match up to, are you addressing each side's arguments? If you're addressing the cases where the plaintiff wins, you're probably addressing cases that the plaintiff is relying on. If you're addressing cases where the defendant wins, you kind of get the same thing. And so one of the things we saw here was there was a heavy reliance on defendant winning cases, but not much on plaintiff winning cases. So that suggests they're not identifying and they're not discussing enough of the underlying cases that rule for the plaintiff. And in fact, we suggest a case that they might want to address, which is Guerrero here, which is a plaintiff winning case. Turns out in the Supreme Court decision on this, the Supreme Court relied on Guerrero and subtly suggested, as I read it, that the defendants here should have addressed Guerrero because the Court of Appeal had discussed it. So it had come up in the Court of Appeal. The Supreme Court would have expected some discussion because it was important to the Court of Appeal's ruling. That never made it here. Our software automatically picks that up. A couple other things that are interesting are on, this is our cases tab. So what we're looking for here are, does the brief rely on cases that are likely to be followed, and do they cite to cases that are actually citable? So in California, we have a rule, at least up through 2016, June 30th, 2016, cases that had review granted by the California Supreme Court were automatically depublished and rendered not citable. You could not cite to it, and you could be sanctioned for citing to it. This was filed in 2015 while that rule was still in effect, and it relies on Monares, which is a case that has had review granted, or had review granted at the time on February 13th, 2013, never been cited in a judicial opinion for the reason that it's been depublished and is not citable. So that is, as I see it, Law School 101. You learn how to shepherdize a case at the very beginning of law school, and we have a couple major law firms not doing that properly. We'll also look at arguments, and this is a bit more of a statistical measure, but generally seeing who's likely to win in the legal principles that are being applied in the case or being argued over. And so we evaluate, we pull out the legal principles, we look at who's winning, whether plaintiff or defendant in cases that apply that. And over the course of all these cases that apply the legal principle, we get a set of basically an estimate of the odds of success of this motion. Or this brief. We saw recently in a Google pay discrimination lawsuit, the plaintiffs, so a little bit of a story here, but Google filed a demur to the plaintiff's complaint. Demur is trying to get rid of the case. the plaintiffs filed a opposition, and in their opposition, this sort of pie chart was very favorable to defendants, which would have been Google. They lost on their opposition to the demur. They amended their complaint. Google filed a second demur, very similar to the first one, but in the opposition to the second demur, the plaintiffs relied on a different set of arguments, and the arguments, the pie chart here was actually favorable to plaintiffs, and they won on that. So there's this selection of arguments that you make, and it has some odds associated with it. And a lot of that just comes down to, if you look at the arguments, are they plaintiff favorable, defendant favorable? Do they have sort of mixed outcomes, but having the right sort of balance? And that also goes.
Sorry, I don't,
yeah.
Maybe I keep my question for later, but how do you do this automatically to determine which arguments are favorable to plaintiffs?
Yeah, so this Judicata has been around since 2012, so we're actually not a young company at this point, and the core development of the company for the first 5 years was mapping California law. And the bulk of that was building out technology that could automatically process and understand case law, and then have a thin sliver of human review on top of that to identify manually anything that couldn't be automated. So we have a backing of data that is being used. When we upload the brief, we parse it, we evaluate what's going on in it, and we compare it to our map of the law. And so that allows us to make suggestions. We can say, look, you're doing X, Y, and Z. We actually know, what the cases are about, who wins, and we can evaluate because we have that map. So it's kind of like with
down to the argument level, okay.
Down to the legal principle and argument level. Yeah. So this is still kind of in the early days proxy, and it's going to get deeper and deeper and deeper as our map of the law gets more detailed. But already we see that this is a good sort of evaluation of the odds. Couple last things, so I don't take too long. I've talked about sort of the drafting, which was the cites, quotations, and supports that we grade, the arguments, which was the outcomes, cases, and last arguments tabs. We also have context, which is looking at how similar cases fared. So similar being stuff that involves the same cause of action, arising on the same procedural posture, in front of the same judge. And we will evaluate, whether the situation is favorable to the particular party, and down to, with the judges, how do we expect things to fare. And so here what we have is that the defendants here were kind of in a weak situation. The odds were against them, and so it's not a surprise that they lost within, on that sort of basis. However, we do see occasionally we do see something interesting, which is that second to load. This is another brief, sort of demo brief that I'm loading. So the arguments is coming up with a statistical measure of how likely this brief set of arguments and the way it's presented are likely to win. Context gives the statistical likelihood based on similar types of cases. We get these disparities where the context is substantially higher than the arguments of the brief. When we see that, those briefs tend to lose at a higher rate. So this brief actually did lose. It has an elevated chance of losing, which we see because the arguments are less well presented, they're less balanced, they're relying on cases that are more likely to be distinguished, and the arguments are more favorable to the opposing party. And so we can pull that out and automatically identify briefs that have an elevated chance of losing. It's not going to be like a perfect sort of prediction, but we get, I think, around 72% on this.
And what are you considering context?
Context is looking at, so we have that map of the law, and so we're looking at cases that arise on the same procedural posture. So in the last brief, a motion for class certification. On this brief, this is the motion for summary judgment, I believe. We're looking at what party is filing the particular brief, and then the causes of action. So I forget what this one is, but the Dynamex one here is wage and hour claims, so failure to pay overtime wages, that kind of stuff. So we can say, how often does a plaintiff have class certification granted in a failure to pay overtime wages case. And if it's a lot, then plaintiff's in a pretty good position, the average plaintiff. If it's not a lot, they're in a relatively bad position. And so you have just baseline odds, which any lawyer probably has a decent sense of what cases are likely to work. And we see that with different motions and different causes of action, the relative odds are different. So that is pretty much what we have with Clerk here. It's
cool. That's great. Yes, fantastic. So any questions for Itai?
I have one.
Yep.
This is great. I mean, it's striking that we need spell check for quotation, quantification, and for doing that because it's necessary. On the outcome, yeah, you had something where you suggested Guerrero, which had been amended in his brief, but then later the court said that it should have been included because the appeals court referred to it.
Yeah.
How did you find out that?
Yeah, so that's a great question. So, and actually I'm going to use the divert for 1 second, which one of the things that we've done with Clerk is the more briefs we run, the more we learn. And one of the things we learned from this is, oh, well, we should just line up the brief at the Supreme Court level with the decision from the Court of Appeal and see what did they miss. However, we haven't done that yet, but numerous of our features are like, oh, well, you know, how do we just automatically check it that way? In this particular situation, we have, we break down the cases into those where the plaintiff is winning and those where the defendant's winning and those with mixed outcomes. And that gives us this pie chart here. Within each of those cases, we offer, from a research perspective, a tool here to help find cases that either support your side or attack your side. So depending on whether this is your brief or your opponent's brief. So here what we do is, if we look down at Martinez, for Martinez, this is a case that rules for the defendant. We break down all the cases that cite to Martinez into those that follow Martinez and those that distinguish Martinez. And then also those where the plaintiff wins and those where the defendant wins. So we have what we call here an outcome matrix where you can look at that, and the cases in green are generally cases that are supportive of Martinez along whatever dimensions, and the cases in the yellowish orange quadrant are against. So we look for cases here that are along the dimension you should be citing to. So here in this particular brief, they were citing to not enough plaintiff winning cases. So we look for plaintiff winning cases in one of these outcome matrices that are especially relevant based on a similarity metric. So we separately evaluate how similar each of the cases are, and then we look for ones that are especially relevant. And so Guerrero pops up on this. And we see that a lot. We've had another case, another pair of briefs where the brief was a motion for summary judgment and the opposition for some reason was relying on demurrer cases, which is a different procedural posture. And that main demurrer case they were relying on was distinguished by a case called Aguilar. And Aguilar was actually on point, was the right posture, and we suggested that. So it's kind of, while it may look just magical, these cases come up, it's actually, again, mapped against this legal understanding.
Cool. So Ruben's asking, says, genuine question, what's the pricing model? Any litigation funders on your customer list?
Any what?
Litigation funders.
Litigation funders. That's something we've been interested in, but we haven't pushed hard on yet. I think maybe it could be a couple of years before that gets in there. But the pricing model right now, so there's a couple things. One with Clerk directly, this is on, there's two ways to purchase it. One is on a per upload basis, where we sell them basically in packages of 2. So it's $280 for 2 uploads. So $140 to perform an analysis, which the reason we do that is we want to make sure that even low dollar figure litigations are able to take advantage of a tool like this. So you can just use it, then cancel. On the unlimited package, it's tied to the number of litigators in the California litigators in the firm, and that's $249 per month per lawyer. Okay. So you're paying for unlimited use, but you're having to amortize that across all the vendors.
More questions?
Hey, Itai, this is Jeroen.
Hey.
Hey, been a long time.
Yeah.
So I was wondering, so is the general thinking here that I'm a junior associate, I've drafted a brief, and I'll upload it, and then based on the results of Clerk, I'll optimize it.
There's two things. One, yes, you'll optimize it if you agree with any of the suggestions, and they're not going to agree with the suggestions every time. But two, you're also going to use this to clean up sloppy mistakes. So, for example, the cites and the quotations are things that at least cites historically have been done by law firms, and people pay for it. Now it should be done automatically. But yeah, so cleaning up simple mistakes and also evaluating the suggestions. We are also actually talking with a number of corporate counsel about using this to evaluate the work product of their outside counsel and really sort of drilling down into how good they actually are.
Yeah. How does that would be my question. How does that scale then? I mean, do you expect them to go through all their panel firms and you kind of tie it back to all the litigations that they were in and the decisions that came out, and then you...
So yeah, there are a few ways
to give a rating and say like, okay, these guys really did a poor job.
Yeah, so there are a few ways to do it. One, we've already published an analysis of the 20 largest law firms in California, a ranking of them, and we're going to be expanding upon that. So we're going to be doing a lot of that analysis. Separately, I talked to a guy at an insurance company. They actually would go and talk to their outside counsel, get briefs from them. This was a couple decades ago, and literally grade the briefs manually. Go back to the lawyers and ask, why did you do X, why did you do Y? And every time they would do that, lawyers the next time around would have a higher scoring brief. So you can kind of selectively do it just to make sure that the law firms know that the clients are paying attention. They know they're being monitored, and especially now that they can be monitored quickly, automatically, inexpensively, then I think the law firms are going to be forced to be more efficient and produce better work quality. So for example, in this particular situation, this Dynamics case, this is filing in front of the California Supreme Court, and yet it's a really poor document. I think we're probably going to hopefully stop seeing that type of work quality within the next couple of years.
And what do you trace it back to? I mean, is it just sloppiness, or, I mean, this should be adequately incentivized. Every law firm always wants to win the case, right? So they have an incentive to do high quality work, and then it's maybe a question of not having the right
I don't have
research tools, maybe.
Well, no, I don't. I wouldn't call it that exactly. I mean, I think yes, you don't have the right research tools at some level, but it's not like citation checking is a new idea. It's not like quoting the law accurately is a new idea. There are things that we do, like these outcome matrices and other pieces of information that are beyond what a human could do because it's just pulling in too much information, and that data doesn't exist elsewhere. What I think is going on here is it's A, sloppiness, and B, a lack of training. So law firms are not run like, efficient businesses where you have quality control and training. When I was a software engineer at Google, I had to go through many different training sessions on how to use different technologies, and I had to get certified on them. I could do it all from my computer at my desk, but still I'd have to go through that and get the certification to work on things. Then when you file or when you basically do the equivalent of filing a bit of code, when you commit code, you have a reviewer who looks over it and asks you, why did you do this? Why did you do that? Check this, check that. So there are industries that have that oversight and training built in. Law firms, I don't think, do that. I did not have that as a
limited degree with, you have like the partner, presumably kind of checking the associates.
Right.
But it could be maybe systematized better.
Yeah, and I think what we've seen is that most of the partners are probably not doing that good of a job. We have seen some examples of partners whose briefs are far better than the average and kind of stand out. But that is it is sort of which partners decide to focus on that. A lot of them I think don't. But the law firms will have a better idea once they start looking at this data and as to why they're making those mistakes.
Can this approach? I mean, this is such an interesting idea. I think we talked about this with Eddie Hartman that legal goods are legal services are credence goods, and you can't really assess their quality until it's too late sometimes. And you are also, I mean, in your approach, you're sort of almost using a retroactive. You're looking backwards to check their quality of work. But based on that information, then clients can make a decision on whether they want to hire that lawyer again or not. But so one of the questions I have is, can this be? This is very litigation focused, but is there any way that you can see this approach being used also for the quality of transactional, to measure the quality of transactional work?
Definitely. I mean, at a basic level, checking, are they misspelling things?
Okay.
Which it may sound sort of minor, but it shows attention. We wrote about this Dynamics case recently, and one of the things I pointed out was it's very hard to find grammar mistakes in the New York Times. Like, they care about the details, and they know that people who read them, if they're going to see a lot of grammar mistakes, it's going to be horrible. So trying to avoid the politics of it, from time to time I go to foxnews.com just to see what's written there, and I open up an article, and it's grammar mistakes everywhere. And that leaves an impression. And it says something about...
More about the content already.
Well, but in any event, the point is that those things are related. And if you're making the small mistakes, you're making the big mistakes. And so I think that, basic things like spelling, there's a question of how do, on a contract level, how do all the clauses fit together? I haven't tackled that. We haven't looked into that. We'd love to go into contracts, but I'll leave that for like the next decade or so.
Great. Are there, we are pretty much at the end of our time. Maybe there's time for one more question if there is one. Yes, sir.
So is there any specific domain where your firm is doing better, like merger and acquisition, or for labor law, or more patent law or something?
So our map of the law is more detailed for employment law, which is sort of a historical basis. We started off in employment law, so we did a lot more work there. So that tends to be a slightly better area than other types of areas we would evaluate.
Do you want to type your email in the chat, and then if people have questions, they can.
Yeah, this is very cool. Yeah, unfortunately we're at the end of our time, but Itai, thank you so much for coming. It's really cool and very exciting to see. And like you said, you've been at this for a number of years, and it's really cool to see what you've built. So congratulations. Thank you all for coming. Our next meeting will be sometime this summer, I suppose.
Yeah, we're thinking the August timeframe, so it will be announced through the CodeX list.
Yeah, so please stay tuned. I wish you all a wonderful summer, wherever it will take you. And check out the Law Geek event tonight in San Francisco. Exciting pitching session there. And see you all next time. Thank you.
Thanks, everyone.
I think